Thank you, Mr. Chair. Just a reminder, everybody, make sure you're using your microphone if you are speaking. Thank you, Mr. Chair. House Study Bill 41 is a joint resolution proposing an amendment to the Constitution of Iowa. It would read as follows: to defend and protect unborn children, we, the people of the state of Iowa, declare that this Constitution does not recognize, grant, or secure a right to abortion or require the public funding of abortion, unquote. This amendment is needed to respond to the judicial overreach of the Iowa Supreme Court. The legislature makes laws, the court interprets those laws. We also need this amendment because without it, we could have late-term and taxpayer-funded abortion in Iowa. In the minority opinion of Justices Mansfield and Waterman, they warned of this when they stated, quote, "I wonder if the majority is laying groundwork, instead perhaps a stepping stone, toward a ruling that Iowa's Medicaid program must fund abortions," unquote. So this possibility is very real. In response to the judicial overreach and to prevent late-term and taxpayer-funded abortion in Iowa, I believe we need to advance this resolution, follow the process to amend the Iowa Constitution, and ultimately allow the voters of Iowa to make the final decision. This concludes my opening remarks.
Do we have any comments? Yes, Representative.
Thank you, Mr. Chair. This is a difficult issue for our state and our nation, and I appreciate the opportunity to speak to the committee. In recent years, this legislature has passed several bills to limit access to abortion. Today's bill is not for just another state law. It's for a constitutional amendment. And it is the most far-reaching that we have seen in decades. It doesn't just put some limits on the right to abortion. It would eliminate the state constitutional right altogether. Given the current composition of the United States Supreme Court, it is possible the court could overrule Roe v. Wade. Without a state or federal constitutional right, there would be no right to abortion under any circumstances. The state legislature would be free to ban abortion altogether. Make no mistake, the proposed amendment is the first step toward banning abortion altogether. That is what's at stake today. I want to make 4 points in opposition to this bill. First, simply put, the people of Iowa do not support this bill. Reproductive decisions and parenting decisions are a critical part of what it means to be a free human being. It should be up to individuals, not politicians, to make these decisions. Iowans value their freedom. And like more than 70% of their fellow Americans, Iowans support a right to abortion. The number of negative comments and emails that this committee has been receiving from Iowans every single day is evidence of that. Second, our history does not support this bill. There is a long constitutional history in the United States recognizing the fundamental right for people to make decisions related to procreation, whether to have children, how to parent them, and so on. Even when abortion was illegal in Iowa, the enforcement told an interesting story. Women were never prosecuted for getting abortions. And doctors who provided the abortions were rarely convicted unless the woman died. The law was used primarily to protect women's health and well-being. Third, we frequently hear people talk about late-term abortions or abortions right up until birth. They argue we need a constitutional amendment to prevent that. Let's be clear. Abortion right up until birth is not a thing. I don't know anyone who supports that. It's a disingenuous argument used to stir up fear and confusion. It is not real. Finally, this amendment is bad policy and bad governance. It would not stop abortions, but it would endanger women and families. After so much progress on gender equality, it would set us back decades. As it was long ago, a person's fate would be tied to their reproductive status, and people would not be free to make difficult decisions in the best interest of their families as a whole. The comments on this bill show that many Iowans think it's especially cruel to consider this amendment now, during a pandemic, when so many families are already struggling to stay healthy and make ends meet. Good government should defend a person's right to make deeply personal decisions. It should give them options when they're struggling, not kick them when they're down. And most importantly, in a democracy, good government should not allow politicians to take away constitutional rights based on their own personal beliefs or preferences. It should listen to the will of the people. I urge this committee to vote no on this constitutional amendment. Thank you, Mr. Chair.
Do we have any additional comments? President Westbrook.
Thank you, Mr. Chair. Thank you, Representative Bohannon, for some great comments. House Study Bill 41 is at the very least insulting. It risks a woman's life when we should be creating access to quality health care for all. We should address access to prenatal care where we can really save children. And we should be addressing our elevated maternal death rate. 77% of Americans support Roe v. Wade. The Iowa Supreme Court decision does not expand the right to abortion and in most ways mirrors Roe v. Wade. The Constitution must protect us from the extremist agenda proposed in this amendment. The constitutional amendment puts both infertility treatment and birth control at risk. Many Iowans value both of those. There are no exceptions in this amendment for a survivor of rape or incest. There's no allowance to save the life of a woman. Under this amendment, a woman has no right to save her life if she is pregnant. No one wants to imagine these scenarios. But none of us can predict the future. Pregnancy is complicated and every woman's experience with pregnancy is unique. Sometimes a woman may experience a health crisis or the pregnancy cannot survive. She deserves to make decisions about her reproductive health. Now more than ever, we should be listening to medical professionals. Repeatedly, we have heard from obstetricians that tell us restriction to abortion care is dangerous. Iowans place trust in their doctors. Good leaders listen to experts. In this case, that would be obstetricians. In subcommittee, speakers misled by claiming that the Reynolds decision would lead to abortion up to the point of birth. There is no such thing. And the court addressed this absurd accusation in both Roe and Reynolds. In Roe v. Wade, they concluded the following from page 15. We therefore conclude that the right of personal privacy includes the abortion decision, but this right is not unqualified and must be considered against important state interests in regulation. Former Chief Justice Cady made a nearly identical conclusion in the Reynolds majority decision on page 55. No court has held, and we do not hold today, that a woman's right to terminate a pregnancy is unlimited. The Republican constitutional amendment is based on ideology. It is not based on fact. It is not based on medical science, and it is not based on the facts of the Iowa Supreme Court case. We have real problems to solve, and we need real leadership to solve them. Chief Justice Cady from the Iowa Supreme Court decision wrote, autonomy and dominion over one's body go to the very heart of what it means to be free. At stake in this case is the right to shape for oneself without unwarranted governmental intrusion, one's own identity, destiny, and place in the world. Nothing could be more fundamental to the notion of liberty. Again, Iowans are looking for leadership. Chief Justice Cady was a great leader. We cannot be a state that would deny a woman autonomy over her body and expect young women to want to live here. This amendment is reckless, insulting, and diminishes the value of women and mothers in Iowa. I encourage a strong no vote.
Any additional comments? Hearing none, turn it back to Representative Gold.
Thank you. Just to respond to a few of the comments that have been made, Representative O'Hanlon, I think it's far-reaching when the Iowa Supreme Court treated a fundamental right to abortion subject to strict scrutiny, which did not previously exist in the Iowa Constitution, and is a higher standard than even federal court decisions in Roe v. Wade and in other court decisions related to abortion. Iowans do not support taxpayer-funded abortion or abortion up until birth. And Representative Bohannon, you said that late-term abortion was not a thing. Well, let's look at that. Let's look at who's fooling whom. In 7 states, Alaska, Colorado, New Hampshire, New Jersey, New Mexico, Oregon, and Vermont already allow abortion at any time for any reason, even up to the day of the baby's birth. We had 2 Supreme Court justices in Iowa, Justice Mansfield and Justice Waterman, that warned that almost no ban on abortion could stand the standard that had been created in the Planned Parenthood versus Reynolds decision. They talked about the possibility of taxpayer-funded abortion, and they talked about the possibility of abortion all the way up until birth. So we're sort of being led today to believe that these things are fear-mongering, but I don't think it's fear-mongering when we have 2 legal experts, 2 Iowa Supreme Court justices, no less, that are warning that 2018's Planned Parenthood versus Reynolds is a stepping stone to making Iowans pay for abortions. I think that's very real. And again, we've already talked about 7 states that already allow abortion up until birth. And we're talking about a strict scrutiny standard that's been established by the Iowa Supreme Court. Who's fooling whom when 11 states, Alabama, Alaska, Florida, Idaho, Iowa, Kentucky, Nebraska, New Jersey, Rhode Island, West Virginia, and Wisconsin have already seen their partial birth abortion bans struck down by radical courts, a horrific procedure that very few Iowans and very few Americans support. Who's fooling whom when the taxpayers in 14 states, Alaska, Arizona, California, Connecticut, Illinois, Indiana, Massachusetts, Minnesota, Montana, New Jersey, New Mexico, Oregon, Vermont, and West Virginia have been required to fund elective abortions, and the Hyde Amendment on the federal level did nothing to stop it. Who's fooling whom when all 4 of the Democrats' leading candidates in the last presidential election openly supported abortion up to the day of a baby's birth and said they would like to have American taxpayers pay for it? Who's fooling whom when the Democrat Party's national platform calls for taxpayer funding of abortion? Those, I think, are facts. So I believe the people of Iowa and now unelected judges of the Iowa Supreme Court should decide how Iowa regulates abortion. U.S. Supreme Court Justice Neil Gorsuch, in a rare interview given recently, made the following statement that must be considered as we're thinking about this resolution. He said, quote, "Folks who disagree with originalism sometimes call themselves living constitutionalists. Well, who wants a dead constitution? I don't. I want an enduring constitution, and the idea of originalism is just simply that judges should follow the original meaning of the words on the page and neither add things that aren't there nor take away things that are there. And I worry that both of these things happen when we depart from the original meaning of the Constitution," unquote. He then pointed out the Dred Scott decision as a glaring example that the courts don't always get it right. And he said, quote, "The first time the Supreme Court really departed from the original meaning of the Constitution was perhaps in Dred Scott, when the court found the right for white persons to own black persons as slaves in the territories of the United States. He said, scour the document as long as you want, you will not find that right there. They made it up," unquote, and indeed they did. Contrast this perspective with the reasoning of the Iowa Supreme Court 2 years ago. When the Iowa Supreme Court struck down our 72-hour waiting period, the majority opinion stated that we had, quote, freed ourselves from the private views of the Constitution's founders, unquote. The opinion went on to state that the Constitution should instead be interpreted by the, quote, current prevailing standards that mark the progress of a maturing society, unquote. So the judicial reasoning stated in this ruling, creating a fundamental right to abortion when none actually existed in the Iowa Constitution, is the exact opposite of the reasoning stated by Justice Gorsuch and how courts should read and decide cases. And it goes to the heart of his fears of what might happen to our Constitution if things are added or taken away from the words that are actually in the Constitution. And I share his concerns. I believe that the people of Iowa, through their elected representatives and not unelected judges of the Iowa Supreme Court, should decide how Iowa regulates abortion. And if the prevailing standards of a maturing society truly are the prevailing standards, then surely they would be reflected in the makeup and decisions of the legislature and would not need to be mandated by an activist Supreme Court stepping outside its constitutional bounds. The implications of this ruling go far beyond abortion. This ruling challenges the very way our republic functions. It challenges the legislature's constitutional role in government to make laws. If the Iowa Supreme Court is the final arbiter in determining what should be added to the Constitution, as well as what laws should be struck down, then we, the elected representatives of the people, and they base their rulings on what is written in the Constitution, not that, but instead upon their unique view of what constitutes the current prevailing standards of our society, then those of us serving in the House and Senate should simply take our pens and papers and go home because, folks, we just became irrelevant. The legislature makes laws. The courts interpret, but not under the philosophy expressed in the ruling that struck down our 72-hour waiting period. This is the first reason that I believe we need the Life Amendment, to respond to the challenge to the people's authority through their elected representatives that is expressed by the majority opinion that struck down our 72-hour waiting period and ultimately led to a lower court striking down our heartbeat protections. Again, it is the people of Iowa, through their elected representatives and not unelected judges of the Iowa Supreme Court, that should decide how abortion is regulated in Iowa. The second reason we must have a Life Amendment is that without it, we are likely on the way to late-term and taxpayer-funded abortion in the state of Iowa. The ruling striking down our 72-hour waiting period, which led to a lower court ruling striking down our heartbeat protections, created a fundamental right to abortion subject to strict scrutiny in Iowa. Under this ruling and its application, none of our protections are likely to stand against court challenges. That includes our 20-week ban and our ban on taxpayer-funded abortions. And again, to quote Justices Mansfield and Waterman, quote, I wonder if the majority is laying groundwork instead perhaps a stepping stone toward a ruling that Iowa's Medicaid program must fund abortions. For these reasons, I believe this resolution is very necessary. Mr. Chair, I'll move the bill.
Can I respond?
Representative Holt moves House Study Bill 41. Clerk will call the roll.
Representative Holt.
Yes. Yes.
Representative Gustafson.
Yes.
Representative Wolf.
No.
Representative Bohannon.
No.
Representative Hansen.
No.
Representative Height.
Aye.
Representative Jacobson.
Yes.
Representative Jones.
Aye.
Representative Kaufman.
Aye.
Representative Klein.
Yes.
Representative Losey.
Yes.
Representative Meyer.
No.
Representative Mitchell.
Yes.
Was that a yes?
Yes.
Representative Joe Olson.
No.
Is Representative Eric Olson still excused? Representative Osmondson.
Yes.
Representative Salmon.
Yes.
Representative Wessel Rochelle.
No.
Representative Westford.
Yes.
Representative Wheeler is excused. Representative Wilbur.
No.
7 noes and 12 yeses. So 12
yeses and 7 noes.
Vote is 12 yeses, 7 noes, and I turn the chair over to Representative Holt.